Good morning and welcome to the 14th meeting of the Justice Committee. We have no apologies. Agenda item 1 is consideration of 2 United Kingdom Government bills on the issue of legislative consent. I refer members to paper 1, which is a note by the clerk. Do members have any comments on the Private International Law Implementation of Agreements Bill or the Domestic Abuse Bill? Okay, if members have no comments to make, are we agreed that the Scottish Parliament should give its consent to the relevant provisions in Private International Law Implementation of Agreements Bill and the Domestic Abuse Bill? Are members content to me as convener to arrange the publication of a short factual report on the outcome of the committee deliberations? Are we agreed to both these suggestions? We are agreed. Thank you. Agenda item 2 is formal agreement of the work programme decisions taken at the committee's informal meeting on the 20th of May. I refer members to paper 2, which provides a summary of those decisions. Are members content to confirm the decisions made? We are content. Thank you. Agenda item 3 is a continuation of our evidence taken into the challenges in restarting jury trials in Scotland courts. I welcome our first panel of witnesses today, Ronnie Ranucci, QC, President, Scottish Criminal Bar Association, and Kate Wallace, Chief Executive, Victim Support Scotland. I refer members to paper 3, which is a note by the clerk, and paper 4, which is a private paper. And I invite Mr. Ranucci to make a short opening statement. Mr. Ranucci.
Good morning, convener. Good morning, committee members. Can I say, first of all, thank you for inviting me along to give evidence today. Can I say at the outset, there is no doubt that the Scottish Criminal Bar Association and the Faculty of Advocates as a whole very much recognises the scale of the challenges faced by the criminal justice system, particularly in relation to restarting jury trials. But as we have stated previously, those challenges cannot and will not be solved without keeping justice at the centre of the solution. I think it's fair to say that at the start of this crisis, we as a body did not think we would be spending much to resist the abolition of jury trials. And so we have viewed our role in this process really as twofold. First, as a defender of that integral and indispensable part of our criminal justice system, which also plays a key role in our democratic process, namely trial by jury. And secondly, to do what we can as a body to utilise our expertise and our practical experience to assist in getting our criminal justice system back up and running as effectively as it can in order to get us through this temporary crisis and the extraordinary challenges that it brings. We remain vehemently opposed to non-jury trials, and it's perhaps important to emphasise that again. And I say that because notwithstanding the widespread opposition to non-jury trials and the fact that the Cabinet Secretary has said it's no longer the Scottish Government's preferred option, and indeed as far back as the 21st of April, he stated that the options now being considered were those with the most support, namely options 1, 3, 6 and 8 in the government discussion document. That spectre of non-jury trials was raised again as recently as the 19th of May by Eric McQueen, the Chief Executive of the Scottish Courts and Tribunal Service, when he addressed this very committee about the potential backlog. And of course, the Scottish Courts and Tribunal Service have the key role in implementing the solutions that will be chosen by Parliament. The Scottish Bar Association recognises that there will be a backlog, as indeed there will be in all public sectors, including dentistry, medicine, teaching. We are not alone in that area. And to some, non-jury trials may seem the cheapest and most convenient way of addressing that backlog. But cheap and easy is not a sound basis for any criminal justice system. Convenience should not somehow outrank or take precedence over justice. If these are extraordinary challenges, then we must employ maximum extraordinary efforts to meet them. And the Scottish Criminal Bar Association are prepared and willing to meet those challenges. And we are pleased and delighted that after only 2 meetings of her working group, Lady Dorien has announced that 2 initial jury trials will proceed in July, with more trials no doubt rolling out after that. And we also welcome and acknowledge the amount of hard work and indeed continuing efforts of the Scottish Courts and Tribunal Service that have culminated in the recent announcement of the resumption of preliminary hearings and other various procedural hearings, including, as we understand it, the taking of evidence commission, that will begin to call again at the High Court as of the 8th of June. We believe that the options currently being pursued by government and featuring in Lady Dorien's pilot trials are workable, proportionate, and are the best way forward to address the present issues. And we as a body are committed to them. And once we are back to some form of normality, we can, of course, get down to addressing the remaining backlogs. And we see that as being done by the option that was envisaged in option 6 of that discussion document. Thank you.
Thank you for that. I now invite Kate Wallace to make a short opening statement. Kate.
Good morning, convener. Good morning, members. Thank you very much for inviting me. The letter that I submitted before, we wrote an open letter along with a number of other victim organisations, and we are deeply concerned about the impact of lengthy and prolonged delays to court proceedings on victims and witnesses. We ourselves have seen a 400% increase in the numbers of safeguarding reports that have been escalated where victims and witnesses have reported having suicidal thoughts. That increase was from March into April. The delays and the uncertainty around court are having a devastating impact on victims and witnesses across the country. And we are deeply concerned that the options that are being explored at the moment still focus on the involvement of a jury. There are no options being currently pursued around feasibility where a jury is not being looked at, and we are concerned about the risks around that. Mistrial, as we've said before, has a devastating impact on witnesses and is worse in a lot of cases than not starting a trial at all. And we're aware from Eric McQueen's evidence that he gave to the committee before just about the size of the backlog. 1,200 in March 2021, rising to 1,700 for solemn cases in 2022, and then 2,000 outstanding trials in March 2023. We're aware as well that there would normally be 16 solemn courts running per day, and any options that are being looked at around that just do not even scratch the surface of those kind of numbers. And we are also aware that we were already facing a backlog within particularly the solemn courts. So we would urge that as a temporary measure related to this emergency that is now becoming an emergency in our courts as well, that work has started to explore the possibility of juryless trials as a last resort and as an emergency and temporary measure. We would be interested to find out why some of our colleagues within the legal profession are so resistant to that when we're aware that it's been used in other places, for example in summary proceedings. And Rape Crisis Scotland themselves have called for the exploration of a 3-judge option similar to what was used in the Lockerbie case. So that's really our position.
Thank you for that opening statement. Before we go to questions, can I thank both witnesses for the written submissions, which are so very helpful for the committee before we take formal evidence. We now move to questions, and can I just remind you to please allow broadcasting staff a few seconds to operate your microphones before you ask your question or provide an answer. And our first question comes from James Kelly. James.
Thank you, Convener. Good morning to Kate and Ronnie. Lady Dorien has set out some initial arrangements with the objective of restarting High Court trials in July. And I ask both Kate and Ronnie, are they supportive of these measures, and what steps do you think need to be taken to build on that work to get more trials up and running?
We'll start with Kate, since you mentioned Kate first. Kate.
Thank you. Yeah, we're very supportive of it, and I think as much as we can do, we're really interested to see how it goes and how it works. We've obviously got concerns about if anything goes wrong, particularly if one of the jurors or a few jurors becomes unwell, and what happens there. As I've said before, we're worried about mistrial, but we are aware that the approach that's going to be taken to limit the amount of in a court using a number of rooms means that there'll be a vastly reduced number of trials being held than would normally be held. As I said, there would normally be 16 a day in solemn procedure, and we'll be absolutely nowhere near that. But yeah, I think anything that we can do at the moment to try and get trials restarted is a step in the right direction. From our point of view, we would like to see that encompassing all of the available options rather than a selection of them.
Same question to Ronnie.
We very much support the proposals by Lady Dorien. We see both options. As the committee will know, there are two options. One running in Glasgow with socially distanced juries and the jurors, I beg your pardon, socially distanced within the courtroom, and the other with the jury socially distanced together but watching it remotely. The benefit of that second one is that it reduces the number of rooms, and I say rooms, not courtrooms, that require to be used, because in that second scenario, the jury can remain within that room where they're watching the trial for their deliberations. And I emphasize their rooms and not courtrooms, because I'm aware that the three courtroom model, which Eric McQueen referred to, and in which there were plans for, involved the use of three courtrooms for each trial, and we do not think that is necessary at all. In fact, it would be an entire waste of resources, court resources, and that can be achieved. The increase in the trials, the number of trials, can be achieved easily by the use of other court estate rather than courtrooms. So instead of having, in the one model, where you have the courtroom, where you will have the participants and the jury sitting together, so all socially distanced, then there has to be another courtroom for the jury to retire to, and another courtroom for the press and public. Then you don't need them to be courtrooms. And if they are not courtrooms, then that frees up other courts in order to run other trials. Now, I appreciate that Eric had said that 16 trials normally run. Of course, they don't run 16 trials every single day. But there are 16, there is the capacity in a High Court for 16 trials. But we very much see that the increase in the number of courts, that he mentioned 5, but I think in fairness to Eric McQueen, that was on that 3-court model, and I'm aware of the response that he gave to the committee, where he confirmed that each room does not have to be a courtroom, and that would free up other courts. And also the fact that if we were using the second pilot, which is the remote jury, then again, that would allow more courts to free up. And we have anticipated that we could maybe run as many as 10 trials, 10, 11 trials on a daily basis. And that does take us somewhat closer to the 16 that Eric McQueen mentioned. And that would decrease the backlog in the long term, and then we can address the backlog after that.
Thank you. James Kelly, do you have a follow-up question, James?
Can I just ask, Ronnie, you clearly see you've got reservations about going ahead with or you support going ahead with using the 3 venues. You would prefer an alternative option. how do you see social distancing still being observed by going to like a one venue solution?
Ronnie.
I'm not talking about a one venue. I'm not talking about a one venue solution. I'm still talking about 3 separate rooms, but they don't need to be courtrooms. For example, in the Salt Market in Glasgow, where the High Court is, there are presently 9 courts. Not all of them would be suitable for social distancing, but there are 6 very large courts. You don't need to use 3 of those courts, for example, for one trial. I think Eric McQueen said that he thought with a 3 courtroom model, that's using 3 courtrooms for each trial. But of course, there is other estate within Salt Market. There are other rooms that are large enough where you do not need to use the courtroom. For example, there are large juror muster rooms which will not be used because we will not be bringing unimpanelled jurors to the court. And indeed, that unimpanelled, the muster room was previously used in the last trial that finished in Scotland. That is where the jury went to deliberate. And the smaller courts could be used. And there are other rooms within that building. There's a large cafeteria. So we are saying that even if you have 3 rooms, one being the courtroom, and then you have another room for the jury and another to deliberate and another room for the press, they don't all need to be courtrooms. And if they're not all courtrooms, it frees up the courts and allows more trials to run.
Okay, thank you for that. The next question is from John Finney. John.
Thank you, Convener. Good morning, panel. My question's for both the panel members, and it's already been touched on in part, Convener. The Chief Executive, Mr McQueen, of the Scottish Courts and Tribunal Service, has commented on the backlog of solemn trials, saying it's likely to exceed 1,800 by August of this year and could exceed 3,000 by March of next year. Now, he explained, and Mr Ranucci's touched on this in part, that with social distancing in place, the court's capacity could be cut by to a third. I wonder if the panel would comment on the view of these estimates, and if they're accurate, what they think the implications are for both accused and victims, please.
Kate, if I direct this question to you first and then Ronnie next.
Okay, thank you. Yeah, well, obviously Mr McQueen is better placed to assess the figures from his perspective, as he's been tracking through the backlog for some time. My understanding is that the figures that he produced for you were taken into account different phases of post-lockdown, and that was all encompassed within the figures. So yeah, I mean, as I said earlier on, we are deeply worried about the size and the scale of the backlog and the length of time that it will take for this to work through the system. We think that for victims and witnesses, you're stretching into years, and that is unacceptably cruel to people to leave them waiting for that long before they can see justice done. From my organisation's perspective, there's 2 kind of main interests around the solemn cases. We run the National Service supporting families bereaved by crime. So that's families who've been bereaved by murder or culpable homicide. I can tell you that those families are really, really struggling at the moment with the lack of certainty around when those cases are going to come to court and when they're going to see justice done on behalf of their loved ones. They are really, really distressed. The other group of that we support and work with alongside Rape Crisis Scotland and others are those who are victims of serious sexual assault and rape. And for those victims and survivors, waiting to give evidence in a trial is a huge weight hanging over them. And the longer that goes on, the more they feel as though they can't get on with their lives and move on and put it behind them. And again, we would say that dragging that out for years is really unacceptably cruel on those people as well.
Thank you. Ronnie.
We entirely understand the difficulties that it will cause witnesses, that the backlog will cause witnesses and complainers in cases who will have to inevitably wait in some situations, in some trials. But again, that is something that's going to be happening throughout society with There'll be hospital backlogs, there'll be people waiting for operations. Cancer treatment has been delayed. That, unfortunately, is an inevitable consequence of COVID-19. But we are conscious of that, and that is why in each stage we have proposed solutions that we see as means of getting through this. And once we are out at the other end and we're back to normality, getting back through the backlog. So far as the 30% is concerned, well, again, that was using that 3 courtroom model, i.e. each room has to be a courtroom. If you strip that away, as we've already explained, and as Mr McQueen accepted in his response to the committee, not each of the rooms has to be a courtroom, then that capacity will be increased. And that means that the backlog will be smaller. As so far as the numbers in the backlog, I can't dispute what Eric McQueen says. I haven't seen the working. I understand if those are the figures, those are the figures. Considerably less than the 38,000 that there will be down south. But can I say this? At some point, we will get out the other side of this. We will get back to normality. And that is when we begin to get through the backlog. That is when we make inroads, large inroads into it. And perhaps the easiest solution to that, or the easiest answer I can give as to how we do that, was provided by Eric McQueen himself when he gave evidence to the Justice Committee on the 19th of May. And indeed, I think it was about at 6 minutes past 11, he said to the committee, he says, in a normal set of circumstances where we had a backlog, we would just introduce more courts, we'd introduce more staff, we'd bring back retired judges, and we'd just do things quicker and faster. So there is your answer to the backlog. It's provided by Eric McQueen himself, and indeed was suggested by us in our first paper back on the 30th of March. And you can do that by also doing what used to happen, putting the High Court back out in circuit, taking it to the communities that it serves. The High Court used to sit in various places, not only Glasgow, Aberdeen, Livingston and Aberdeen primarily as it does now. It could go to Inverness, Dundee, Forfar, Perth, Stirling, Dumbarton, Hamilton, Paisley, Kilmarnock. All these places could be utilised once we are out of COVID-19. And can I say, I think Mr McQueen, in one of his responses to you about the court estates, when he was asked about do they only have to be in Glasgow or Edinburgh in the major cities, had said that the difficulties in using facilities out with the major cities in relation to High Court cases relate to the travel involved for those some distance from the Sheriff Court building in question. Well, I have to say, that does not take account of the fact that witnesses from Inverness, Dumfries, all throughout Scotland would have to travel to Glasgow and Edinburgh. It is for those very reasons that we say have these courts, the High Court going out in circuit, and take the High Court to the community. Don't have the community all the way travelling down to Glasgow and Edinburgh to come to the High Court. And in that way, in fact, it would decrease travel if that were possible.
Thank you. John, do you have a follow-up?
I do. Rather than the other question I was going to ask, maybe just ask again specific to Mr Ranucci, the implications for accused of this delay that's clearly, no matter how we seek to resolve it, is going to continue for some time. What are the implications for the individual accused, please?
Ronnie.
That's an excellent point, John, and in many ways the accused has been, I'm not saying forgotten, but has perhaps been moved down the order in relation to this. There is already the fact that there has been a suspension of the time limits across the board, and undoubtedly there will be an impact on accused having to wait longer. But we have seen, comments made about, well, people will have to be in custody for 1 or 2 months. People are in custody for considerably longer than that before COVID-19. But again, in the same, unfortunately, and it is unfortunate, in the same way that it's unfortunate for witnesses and complainants who will have to wait, the reality is that accused will have to wait. But that is why we say, rather than say, well, this can't be done, that can't be done, we can't do it this way, we have the solutions before us. We're considering, let's get on with it. Let's see what inroads we can make into the backlog. And then at the end of it, we can go faster through it with option 6.
Thank you very much.
Thank you for that response. The next question is from me. It's to both panelists, and it's again just touching on what the Chief Executive of the SCTS said, that judge-only trials in some cases should remain an option on the table. He indicated this might just be for the short term or as an emergency measure. Could I ask both panelists your views on jury trials and why you hold these views, and starting with Ronnie. Ronnie, you're muted. Yeah, sorry. Could you start from the beginning again? Thanks.
Oh, sorry. We will remain vehemently opposed to non-jury trials for solemn matters. If you don't have a jury, it simply becomes a summary trial by any other name. Trial by jury is utilised by almost all advanced democracies in the developed world. It involves citizens in the democratic process. It brings together people of all ages, sex, creed and colour to sit in judgment of a fellow citizen. And it allows that citizen to be tried by their peers, not by a single professional judge who, and this is not a criticism of our judges, tend to be drawn from a very narrow and privileged pool. Those 15 jurors provide an accumulation of life experience which marginalise extreme or unrepresented views, and they represent a microcosm of our society. They deliver balanced and rounded decisions on behalf of us, the society from which its members are drawn. And judges often tell juries that they are brought together to make decisions that are too important for a single judge to decide. Decisions that require the collective common sense and life experiences. The importance, perhaps, of trial by jury is best summed up by a quote from Lord Devlin that judges have often repeated to juries. He said, "Trial by jury is more than an instrument of justice and more than one wheel of the Constitution. It is the lamp that shows that freedom lives." And that very much echoes what John Adams, the second President of the United States, said back in 1774, 200 years earlier. Representative government and trial by jury are the hearts and lungs of liberty. And it's as relevant now as it was then. The jury, through its collective decision, make an excellent fact finder. And not surprisingly, and this is very important, the public, the very people they represent, trust juries. That is why juries are so important. And it's to be remembered, and in fact, Kate herself said, as a last resort, non-jury trials. Well, before you have a last resort, you have to have tried something else. We've tried nothing yet, and people are talking about non-jury trials. That is why we are so concerned.
Okay, thank you. Kate, the same question.
Microphone off. Yeah, so from our perspective, and everything that Ronnie said about jury trials, we would agree with. I think the issue for us is that the size of the backlog and the length of time that is going to take to get through is unacceptable now from a perspective of victims and witnesses, and from what we are seeing, the impact is having on their mental health. So from our perspective, it's about introducing a potential for juryless trials into the mix along with the other options, so that we're keeping an open mind about what the solutions to this crisis might be. It's not about replacing jury trials, it's an option into that, because our concerns about jury trials are around this particular situation around coronavirus and the risks that pose, given the number of people that are involved in juries. And also given the length of time that public health experts are telling us that coronavirus is going to be with us for. So from our perspective, we would be asking to add an option that can be explored along with other options of juryless trials.
Okay, thank you for that, which brings me to my follow-up question. What other options do the panel think should be considered? And in particular, Kate, if I could ask you, what are your views on enhanced plea discounts where an early guilty plea means no trial is necessary? Kate?
Well, as you know, Convener, Scotland already has one of the most generous in the world for early pleas, and our definition of an early plea in Scotland can sometimes be the day of the actual trial. From our perspective, speaking to victims that we support, they already struggle with sentence discounting as a process anyway. Given further enhancements about additional discounts to sentences, I think would be even less understood and cause even more confusion and upset. And in addition to that, as Ronnie will no doubt tell you, the concerns that there have been amongst research across the world on vulnerable accused and potentially some bias in terms of early pleas to receive sentence discounts. So from a victim's perspective, it's a hugely contentious and difficult area, sentence discounting for an early plea. And I think the other thing to say as well is in terms of, if we think about particularly families who've been bereaved by murder or culpable homicide, often a trial is where they actually find out the answers to their questions that they've had about what's happened to their loved one. So already for some of the early pleas that we're seeing and some of the processes that are escalating some of that work, my request would be that we give thought to families of victims to make sure that we're giving them the information that they would have had if they had gone through a trial.
Okay, thank you. Ronnie?
I take on board everything that Kate says, but of course, it's been recognised that the point in the purpose in discounted pleas is it recognises that utilitarian value that such a plea gives, because what it does is it means that witnesses don't have to come to court, they don't have to go through the anguish of waiting and then having to give evidence. It saves court time and it saves court money. And as a result of that, that is why there are discounts. Again, just to clarify what Kate says, and certainly, yes, there are sometimes pleas that are given on the day of a trial, but the discount for that is incredibly small, if at all. And it is often the case that the judge will properly find that there has been no utilitarian value to that late plea and will either apply a discount of, in the High Court, a matter of months, or simply will no discount at all. The purpose in it, as I said, was to reflect that utilitarian value. And what we are saying is that in this present crisis, and given the backlog, the utilitarian value of an early plea undoubtedly would be greater in the current climate than it would be in normal times. And therefore, there is an argument, and we would say a valid argument, as to why there should be an increase, albeit a slight increase. And we're not suggesting that it goes way up the scale. We're simply saying that it should be recognised, that increased utilitarian value, and as a result of that, there should be an increase. And that may mean that there will be more pleas throughout this period. Again, I take on board what Kate says about research, about vulnerable accused, but I can assure the members of the committee that people are not forced to plead guilty in Scotland. People only plead guilty, and counsel and solicitors will only plead someone guilty if they accept that they are responsible for what it is that they are going to plead guilty to. We are not in America. We do not do plea bargains where people will just simply plead, even though their position is that they didn't do it. If someone says to me, I want to plead, but I didn't do it, there is no plea. It goes to trial.
Okay, thank you for that. Our next question is from Rona Mackay. Rona.
Thank you, Convener, and good morning, Ronnie and Kate. My question sort of follows on from the Convener's question, and I'm going to try and roll my questions into one just for the sake of time. There seems to be a bit of an impasse between Ronnie and Kate on the view of judge-only trials. Ronnie, can I ask you, do you think the right of appeal could mitigate the risk of someone not receiving a fair trial? And also, you said that the Scottish Criminal Bar Association was ready to step up to the plate and do what they could. Can I ask you about workload and what thought's been given into that? And basically, do you have enough lawyers to tackle this and what this would mean to you? Kate, you've said you're deeply concerned, and can I ask you? You gave some figures in your opening statement about the number of victims that had contacted you. I just want you to put on record that victims are fine with a judge-only trial. They don't have a fear of not getting a fair trial. And do you think the risk is overstated or outweighed by the consequences of not keeping that as an option to the victims?
Ronnie, I'll bring you in first.
Our position remains the same in relation to judge-only trials, but addressing the point about appeals, we don't think that would be an adequate compensation for the loss of a trial by jury, and we see no reason why we cannot have jury trials within this period. It is happening down south. There is absolutely no reason why we can't have it. We know it works, and indeed in England they just completed, as I understand it, the first murder trial under socially distanced conditions. So it does occur, and it works. And there are other means. If it wasn't working under the present system of 15 jurors, then there is that option of looking at reducing it to 7 jurors, as has been done in the past. In relation to the matter of appeal, of course, interestingly, for example, in the Diplock courts in Ireland, there is an absolute right of appeal. And that is an absolute right of appeal is different from leave to appeal, which we have in Scotland. In Scotland, in order to appeal, we have to ask the court's permission, in effect. And it goes through a sifting process. So a judge looks at it and decides whether or not there are grounds for an appeal or the prospects are stateable. And if it doesn't get through first sift, it goes to a second sift of 2 judges. But of course, in the Diplock situation with a single judge, the person has an absolute right. They can appeal against the law, they can appeal against the facts. In Scotland, you really can't appeal against the facts. You're appealing against the law, and it's as a result of a miscarriage of justice, usually to do with the appliance of the legal framework or the law where errors occur, and that allows appeals to be taken. We really do not have appeals in relation to fact. If that was to be introduced, then of course there may well be a backlog in the appeal court. So there would be a knock-on effect.
Thank you. And Kate, the question that Rona directed to you.
Thank you. I've got about 2 parts of it. You might need to remind me about the last part.
Sure.
Because as I said at the beginning of the meeting, we ourselves have seen a 1% increase in the number of safeguarding incidents that have been escalated to management, and those are the incidents focusing on victims and witnesses who are contemplating or thinking about suicide. We're aware we have regular weekly calls with other victim organisations, and those involve officials from Scottish Government. So we're aware that the trend that we've seen is shared across other victim organisations across Scotland. So I'm happy to put that on record. The vast majority of victims that we've spoken to in our organisation, and also the other 3 organisations that signed up to the open letter, those victims and families of victims are in favour of juryless trials on balance. They do recognise that the issues around that, and there are 1 or 2 families who have not expressed that preference, but the vast majority of victims or families of victims have said that they would much prefer a juryless trial or a judge-only trial in order to make sure that the trial actually happens within the next couple of years. So that's really what people have been saying to us. The last part of your question was...
Thank you, Kate. I think you've rolled it into one and you've answered. That's absolutely fine. Could I possibly just go back to Ronnie just to ask about the other part of my question about workload for lawyers?
Yes. I realise.
Ronnie?
Yes, I realise I've forgotten to answer that. There is there would be no issue, certainly with regards to the defence bar, in relation to having an adequate pool of counsel, and also within the whole legal profession, solicitors operating at sheriff court level to deal with the cases that are ongoing at present and the backlog. Something that's perhaps lost is that the Scottish Criminal Bar Association, our members aren't only defence counsel. We also have members who are prosecutors, who are advocate deputies prosecuting in the High Court. And of course, many of us, I included, are ad hoc prosecutors, advocate deputies. So we can change sides, as it were, and do occasionally prosecute. And certainly, if there was a shortage in the prosecution side, then there can simply be more advocate deputies appointed. And of course, advocate deputies can be appointed for very short periods, whether it be 6 months, a year, whatever the period that is required to get through the backlog. And so I don't foresee any difficulty in that area at all, Rona.
Thank you.
Rona, have you covered your follow-up question?
Yes, thank you.
Yeah. In that case, we'll move to Fulton McGregor. Fulton.
Thank you, Convener, and good morning. Trial social distancing as we move to a new normal, if you like. What assurances have you received that adequate measures to avoid the transmission of COVID will be in place for criminal trials? And I'm talking about things like provision of PPE, social distancing measures that might be in place, as you've already referred to. And is there more that you would like to see done in this area?
Kate, if we start with you and then Ronnie.
Sorry,
Kate?
the connection. Try and summarise. So I think what you're asking is what assurances have we been given that the appropriate safety measures to ensure COVID security have been taken? Is that right? Okay.
Yes.
So so individual risk assessments have been undertaken at every single court building, and some are still being carried out for some court facilities across Scotland, as I understand it. And I've been assured that that information will be shared with me so that I can take a decision on whether it's safe for our staff and volunteers to go in to those buildings. Because ultimately, obviously, the responsibility for health and safety of Victim Support Scotland staff and volunteers lies with me. So from that point of view, I'm assured that I'll be given the information to be able to take that decision.
Okay, thank you, Kate. Ronnie.
Thank you. Like Kate, we haven't been provided with the details, but can I say we have got the utmost confidence in the Scottish Courts Tribunal Service that whatever measures are required will be done. Indeed, I was in Saltmarket yesterday, and you can clearly see that they have started the measures that are required. We have a one-way system. Seats have been blanked off in order to ensure that people can only sit properly socially distanced, and it's the same within the courtroom. So we are no doubt that measures have been taken, and of course we would not be going into the whole process where we're not confident, and that is about, I don't have any information about PPE, but I've no doubt, and I have the utmost confidence in Scottish courts that they will be taking the proper advice so that when the time comes and we are able to go back into the courtroom on a more regular basis, it will be within a safe arena.
Okay. Fulton, your follow-up question?
Thanks again, Convener. I'm not sure how good the signal is here, but I certainly heard the answers and want to thank the panellists for that. As a sort of supplementary to that question, what more do you think can be done to provide the public who would use the court with confidence that it will be safe for them to attend either as witnesses or members of a jury or any other business. Is there anything additional to what you've already said?
Is there anything additional, Kate? And then I'll ask Ronnie.
Yes,
Kate?
so just in terms of adding on to what have been some questions asked about what the public health guidance has been, particularly around having jury members in, albeit a large physically distanced room together for prolonged periods of time. And there has been a request for that public health guidance to be shared. I don't think it has been yet, but I would assume that that public health guidance would be beneficial for members of the public who may be witnesses or jury members. We are concerned that there will be nervousness by people, understandably so, around that. So as much information that could be provided, the better. As you know, we are deeply concerned about the potential for mistrial. We think the impact of that will be worse on some victims. So anything that can be done to make sure that the assessment information is provided ahead of time would be helpful. There'll be nothing worse than starting something that we then have to abandon part way through.
Ronnie?
Well,
same question.
The other steps will be that really they can be satisfied that only people who are required to be in the court building will be in the court building, and that number will be greatly reduced. We are looking at the possibility of remote impanelling. In other words, at present, rather than have a whole host of unimpaneled jurors come and be picked, they will be picked beforehand, and so therefore only the people who are required to be in court will be there. If members of the public were worried, what I think I can say with some confidence, given that the Scottish courts are in charge of this and knowing what measures they are taking at present, I am fairly confident that the court arena and the court building will be considerably safer than perhaps other walks of life, for example, that we will have when we go into shops and probably in most workplaces as well. So I think there will be an added level of protection within the court building that there is not within society at large at present.
Thank you for that. The next question will be for Shona Robson. Before I bring Shona in, can I just ask them, the panelists and members to try and be as succinct as possible? This is very good information we're getting, but I am conscious a little bit of the clock. And so if there's repetition of something you've already said, if you indicate that, that would help. But it is a very worthwhile session. I don't want to curtail any new information coming through. Shona.
Good morning to you both. You've touched on this already in terms of the confidence and the public health guidance. So really, just so we're clear that both of you are satisfied that the advice is being based on the best health advice, i.e. from Public Health Scotland. And Kate, you said that you really want that to be shared so that those that you represent and also the staff within your organisation can see for themselves. Am I understanding you correct?
Kate?
Yeah, so we haven't seen any of that information yet. So as I said earlier, I would want to see that information to be able to make that decision around staff, and we think it's that sharing some of that information publicly will assist with members of the public who may perhaps have to attend court either as a witness or a juror as well. So just to be clear, we haven't seen any of that public health information yet.
Okay. Shona?
Okay, that's helpful. And just in terms of my second question is about the pace of easing restrictions. Ronnie referred to the court buildings would actually be more, I guess, safer in terms of prevention measures compared to other areas. So am I right in saying from what you've said that the easing of restrictions, the pace of that, and obviously there's a risk of whether it's too slow or too fast, are you saying that in resuming jury trials that the right balance has been struck? Is the pace correct in easing those restrictions from what you've said so far?
Ronnie?
Yes, it has been accepted that no jury trials could take place during the full lockdown phase. And as we're easing out of that, we can now see the resumption of jury trials. So again, although it would have been nice were jury trials to be resumed quicker than they are, but certainly we are now getting to that stage, and we're as happy as we can be at the pace at this present time.
And Kate, can I add?
Yeah, Shona?
Is Kate wanting to reply to that?
Kate?
I think from our perspective, we would, as I said earlier on, we would want to see other options added into that as well, because we're in hugely uncertain times.
Okay. Thank you for that. We now move to our next question, which is from Alistair Allen. Alistair.
Thank you very much, Convener. Mr. Ranucci, it was a question about some of the options that have been considered. There's been a great deal of public debate, as you mentioned, about juryless trials. There's been less public debate probably about one option that was discussed at one point around smaller juries. And I was just keen to hear your view as an open-ended question about what you think of that option.
Ronnie?
If the option that we're trying just now with a full set of jury, with a full jury, doesn't work, then again, we've already said we have no difficulty, given the current, looking at reducing the number of juries. As a matter of principle, it has happened in the past. It's well documented. It's happened through 2 world wars. And again, the importance of that is, even though it's smaller, it retains that principle of trial by jury. So we would have no difficulty with that if the present options don't work.
Alistair?
And again, picking up on that, and also I think on comments that Ms Wallace may have made, I don't want to put words in her mouth because the line wasn't too good. But I think some, probably including her, have mentioned potential difficulties around collapse of trials. Again, I don't offer an opinion about that, but I wondered if you had an opinion about whether a jury of 7 perhaps is too small to avoid the risk of collapse in the case of 2 or 3 or 1 or 2 jurors becoming ill.
Kate?
Well, the question was for Mr Ranucci initially, but question for either of them, really.
Okay, can we start with Ronnie then, and I'll come back to you, Kate.
Well, again, if we start off with a bigger jury, at the moment, if a jury goes down to 12, then that trial will be deserted. But of course, legislation could be introduced that even if we start off with 15, allowing for illnesses, it could be that that jury could allow to go down as low as 7 before it collapsed, and that would certainly assist in some way. A lot of emphasis has been put on juries and jurors becoming ill, but of course, even if there was judgeless trials, if a member of those participating, whether it be accused, whether it be someone from GOM in the dock, whether it be the judge, the clerk, defence, prosecution. So this isn't something that simply applies if we have jury trials.
Okay. And Kate?
Yeah, we would be concerned about reducing the number of jurors in respect of heightening the potential risk of mistrial. From our perspective, the smaller the number you've got, the more that you run that risk. And also we would be interested, as we've said before, on the public health guidance, for example, around what if a number of the jurors do become unwell? Does that mean that the whole jury has to go home and self-isolate for a length of time? And where does that leave us? So that's some of the concerns that we've outlined already.
Okay, thank you for that. Does that complete your question, Alistair?
Yes, thank you.
Move on to Liam MacArthur. Liam.
Thank you, Convener, and good morning, Ronnie and Kate. I want to maybe develop, like Alistair, just there one aspect of the sort of changes that have been proposed, the greater use of video conferencing, for example, suggested from remote locations that would allow a greater workload to be taken up over the coming months. I don't know if you're aware of work done by the organisation Justice, which has looked at virtual jury trials, where everybody, judge, jury, lawyers, accused, etc., are all interacting remotely. So I would welcome the views of both Ronnie and Kate on the scope there is for the use of video conferencing, and whether or not there are concerns around certain individuals, certain participants engaging remotely in this way.
Ronnie, then Kate. Ronnie.
Well, we certainly see the benefits of remote, of that use of that remote. I think it's fair to say that we see it more in the forum of the Sheriff Court and summary trials. That would seem to be an excellent way of freeing up courtroom and court space that would allow solemn matters to get on if summary trials were done remotely. And we understand that, in fact, trials are being looked at to do that. And of course, civil matters have been held remotely at present as well. Whether or not you can have a full jury remote, a remote jury, I'm not too sure. I have seen it done in England, and I have seen Justice's study, and I have to say, although I was sceptical initially, it was very impressive. But I don't really know if we need that, because we have the options here which would allow us to go on. But certainly that use of technology in summary trials, I think, is something that should definitely be investigated.
And Kate?
Hi there. Yeah, I read the report from Justice around the test that had been done with one remote jury. And I think, it's fair to say a number of issues, both in terms of confidentiality, but also in terms of jurors potentially accessing the internet and looking up information around the case. So there are a number of things I think that would have to be overcome around that for juries, as we've discussed before. There are elements of the remote technology that are being already used and proposed in some of the by SCTS around addressing some of the backlog just now. So they are talking about using remote links between different rooms within a court facility. So I think that we'll see some of that coming through. As Ronnie says, there is a question mark over its use within juries. It's not really it's been tested very, very early days for that. From a victim's perspective, the concern would be around confidentiality and who is standing at the other side of a juror's screen, and who can hear their evidence and who can hear what they say. And certainly victims of serious sexual offences have expressed some real concern to me around that, just to give you an example. So, but you've obviously read that study yourself, so you can see for yourself some of the issues that have occurred with it.
Thank you, Kate. Liam MacArthur, yeah.
I think I've tried to wrap the questions together in one, and while there are issues flowing out of that, for the time being, I'm happy to leave it there. Thanks, Convener.
Thank you. We now move to Liam Kerr. Your question, please, Liam.
Thank you, Convener. And at the outset, just let me remind everyone that although I don't do criminal work, I'm a practicing solicitor with practicing certificates from England and Wales Law Society and the Scottish Law Society. My question's for Ronnie, please. Ronnie, you say it's a matter of regret in your evidence that the English courts are ahead, and indeed they seem to be, with jury trials resuming in multiple locations next week, as you said to Rona Mackay earlier. Now, I think your organisation proposed certain things back in April which mirror England, the system that England's put in place. So why are we lagging, do you think, and what would need to change to address that?
Ronnie.
Thank you, Liam. I'm not sure I said it. I regret we're behind England. in the sense that I think I said it's unfortunate that we are perhaps behind. I appreciate that. I don't know the reasons why. I'm not a politician, and indeed, it's perhaps to me it's not so important the reasons why, but just that we can catch up as quickly as possible. In relation to the second part of that, what has been done in England, we can actually see the genesis of that in our first document that we proposed, our response to the very first coronavirus bill, and that was back in the 30th of March of this year, some considerable time ago. So again, it seemed to us that the solutions were obvious then, and certainly that seems to have been the case in England, because they've either looked at that and thought of it themselves, or they have followed on the recommendations and the options that were being proposed at that time. So precisely why they're ahead, I can't say, but I just hope that we can catch up with them as quickly as possible.
Liam?
Yeah, thank you for that. Very briefly, Convener, I'd like to come back with a couple of supplementaries, which I'll ask you for in a second, but very briefly, just sticking with this point. Just following Liam MacArthur's questioning, Ronnie, you talked about confusion on the availability in your evidence of multi-location video links with prisons. Can you tell us where has that come from, and what would be the impact of sorting it?
Ronnie?
We're not quite sure what the problem was in relation to prisons. There seemed to be a problem with the Criminal Appeal Court initially, but that has been resolved. So our understanding is that that has been resolved. There is a problem with consultations with accused. For some reason, the prisons cannot do three-way consultations. In other words, counsel and the solicitor have to be together. If they're doing it by video link, they can do it by one person being at the other end of a phone, but that is really not satisfactory. So we don't quite know what the technical issue is, but we do know, for instance, that the Scottish Legal Aid Board looked into that with the prisons, and were told that at this stage, certainly, it couldn't be done.
Thank you for that. Yeah, there will be an opportunity for questions after I ask this final one that we were keen to ask, and that's on summary cases. And can I ask the panel what discussions you've had involving the progress of more summary criminal trials, and do you consider there's enough being done in this area? And if so, or if not, what's your main concern? And I'll direct that to Kate and then Ronnie. Kate.
Yeah, we have been quite closely involved. There's a pilot going on in North Region at the moment that we've been involved with. Our main concern around this is to try and make sure that we can give a location that's out with the court, if that's possible. And we have suggested that potentially our offices may be able to be used for that if they can be made COVID safe. That would give witnesses the choice of being able to provide evidence from a different location. And as we know, many witnesses find the whole process of going into a courtroom and a court building extremely intimidating and very distressing. So we're keen to try and progress that if we can, and we're working quite closely with SCTS on that at the moment.
Thank you. And Ronnie?
Thank you. It may well be that my colleagues in the other branch of the profession, the Law Society, would be perhaps better placed. But some knowledge of it, having sat on a number of their committees, they are doing excellent work in trying to progress summary trials, and I understand that there has been an announcement and there is hope to be a resumption of summary trials. But certainly I know that there are ways they are looking at to do it not only remotely, but taking evidence remotely from witnesses. Police officers can simply go into a designated police office where there will be a room there where they can give evidence in that way. And it has also been looked at, as I understand, for civilian witnesses as well. So I do know that the Law Society, together with Scottish Courts, it has to be said, have been working tremendously hard at trying to get them up and running again. I think part of the problem that there has been a reluctance to do anything during the lockdown period, but now that we are seeing restrictions being lifted, we are certainly seeing a movement in the courts.
Thank you for that. I think, Liam Kerr, did you indicate you had a supplementary, or was that answered effectively?
No, I would like to ask two supplementaries, if I may, Convener, one very quickly as a point of clarification and one more substantive.
Yes, if you're quiet, I'm conscious of the clock, but if you're concise, Liam, that should be fine.
Very grateful, Convener. Ronnie, it's directed at you. This is a point of clarity. You talked, or we heard a lot of evidence at the start about having 16 trials per day. And I think you suggested that the single court system that you proposed might get you to 10 per day. Just as a clarity, and I may be wrong on this, but can you confirm my understanding that there are never more than 13 cases running at one time, and often actually in practice it's far fewer?
Ronnie?
Again, I suppose the Scottish Courts Tribunal Service will be able to give you an accurate answer to that. What I can say, I am aware that certainly this year there have been more trial courts running. It's probably impossible for 16 trial courts to run every single day in the High Court, simply because one trial will finish, there might be another one ready to start, there might be a lack of judges. I would doubt that 16 trials will be running every day, but I can't say for certain. But I would have thought that we are probably closer to the 13. But that's not a criticism, again, of the Scottish courts. That's just the system in which we run, and also the fact that, you know, there is a lot that goes into a High Court trial and getting it started, etc. So it's not a criticism. There is that capacity for 16. And although anecdotally, my understanding, what I'm told is it's probably closer to 13, 14 every day, whatever that would be. But certainly if we can get up to that 10, we are getting closer to the normal capacity.
Thank you for that. Liam, does that complete your supplementaries?
No, one of the options that was listed, this is a question for both of you, if I may, but one of the options listed in the discussion paper was an increase in the sentencing power of sheriffs in the summary courts. Now, of course, that would have the effect of removing juries from many cases that are currently prosecuted under solemn procedure in the sheriff courts. Do you take a view, does this lead to a risk that this could result in more serious or complex cases failing to be or falling to be prosecuted without a jury? And if so, do you take a view on that?
And if I could ask both witnesses to be as concise as they could be, starting with Kate this time, then Ronnie.
Yeah, we had expressed a view. We thought that was an option worth pursuing if it was going to help get this backlog down quicker and in a reasonable time frame. So we felt that this should have been looked at.
Okay, thank you, Kate. And Ronnie.
It's regrettable if any offences that are presently prosecuted in solemn level are reduced to summary. But if there was to be a change, then it would certainly have to be at the very low end of solemn cases. And we recognise that there are some cases that are presently charged on indictment, which certainly in my history as both as counsel and as a solicitor were prosecuted at summary level, such as possession of offensive weapon. It was now the carrying of knives, etc. So there certainly would be scope for that, for removing them at the very low end of solemn business.
Okay, thank you very much. That completes the committee's questions for our first panel. Can I say it's been an excellent session, and the committee will reflect very carefully on your responses and answers, which have been, as I say, extremely helpful. I'll now briefly suspend the meeting for 5 minutes, and when we resume, we'll hear from our next panel of witnesses. I now suspend. I welcome our next panel of witnesses, Humza Yousaf, Cabinet Secretary for Justice, and Anna Donald, Acting Deputy Director, Criminal Justice, Scottish Government. And I invite the Cabinet Secretary to make a short opening statement. Cabinet Secretary.
Thank you very much. Convener, first can I thank you and the committee for inviting me to give evidence today on the issue of reopening the court system, with obviously a particular focus on solemn trials. As everybody is now well accustomed to hearing, these are the most unprecedented of times that we live in, and coronavirus has had, and frankly will continue to have, huge impacts across our whole society. It's therefore no surprise that our court service has faced significant challenges in adapting how they work to maintain essential and urgent business, while of course ensuring the protection of the public's health. Difficult but necessary decisions have had to be taken in the management of criminal business. This includes the decision by the Lord President in response to the public health advice to suspend all jury trials. Although this was undeniably the right decision, we must not forget that behind every delayed trials are victims, witnesses and accused. And I know you just heard from a panel who stressed those very points. All of those individuals would be anxious to have their case dealt with and to begin moving on with their lives. I think we would have heard very powerful evidence from Kate Wallace in your last session on just how deeply damaging an impact this can have on victims in particular. And we cannot underestimate, we should not underestimate, the impact on those awaiting trial either. The backlog figures that we face in both solemn and summary cases are stark, eye-watering, and of course grow higher with each week that passes. This was a risk that was identified from the very start of lockdown. It is because of these profound concerns that such a huge amount of work has been carried out over the last 2 months across the justice sector by the Scottish Courts and Tribunal Service, by COPFS, by the judiciary, and of course the government and a range of other key stakeholders, including from the legal profession and the third sector, all in consideration of how to resume jury trials and indeed other court business. I'm very grateful to all those who have given up their time in this most difficult period to help to shape the justice system's response to this ongoing public health crisis. It has been quite gratifying to see that this work has been characterised by collaborative working and a real examination of looking to see what innovative approaches we can take. In a short number of weeks, the courts have resumed many of their services, enabling virtual courts to be held in the Court of Session Inner House and High Court Criminal Appeals and remote hearings to be held in the Outer House. Sheriff courts and mental health tribunals as well have continued some of their work. They've introduced new remote and digital approaches, allowing some cases to be progressed across the Sheriff Civil Courts and the All Scotland Personal Injury Court, and also restarted commissary proceedings through remote working. Protocols have been introduced in the courts to ensure physical distancing where attendance is required, with practice notes in place allowing remote representation to minimise attendance in court by solicitors and COPFS staff. Furthermore, I'm delighted that the Restarting Solemn Trials Working Group has made such swift progress, and as you're aware, the Lord Justice Clerk's Group has identified the steps needed for a small number of trials to take place in Edinburgh and Glasgow in July, using a different approach in each court. Although this will involve small numbers at first, the aim is not merely to get a handful of trials started as quickly as possible, but to establish a sustainable approach that can allow as many trials as possible to progress, consistent with a fair justice system while protecting the health of all those involved. The operation of the Scottish Courts and Tribunal system is of course a matter for the Lord President, so there may be questions today which are more properly for him or indeed for Lady Dorian as the chair of the working group to comment on. But of course I'll aim to provide you with as much detail as I can appropriately do at this time. Of course, Convener, as always, I'm looking forward to taking your questions.
Thank you very much, Cabinet Secretary. We now move to questions, starting with James Kelly. James.
Thank you, Convener. Good morning, Cabinet Secretary, and good morning, Anna. Cabinet Secretary, you referenced the announcement by Lady Dorian of the plans to restart a small number of High Court trials in July. What do you think needs to be done to build on that announcement in order to get more High Court trials up and running?
Cabinet Secretary.
Well, I think James Kelly asks the most pertinent question in relation to this entire issue. And that is exactly the focus of the work of the Lord Justice Clerk's group. It is really on the operational. So I think there is the operational aspects, and Lady Dorian and the group that she has that's looking at this and examining this issue are obviously looking at those issues. So, what has to be put in place in relation to social distancing? What can we do in relation to empaneling jurors? What can we do? Can we do that remotely? How can we ensure that the 2-court system in Edinburgh, the 3-court system in Glasgow works effectively for those involved in the trial process? So we have to allow that work to continue from an operational point of view. I suppose what's not been talked about as much, and I think it is really important, is where people's psychology will be in all of this. 10 weeks of lockdown, a fair degree of anxiety around going out, I think even to the supermarket, let alone being called out called up for jury service. I think there will be a fair bit of anxiety if somebody gets a notice to serve on a jury, to come forward for empaneling. And I think we have to really be cognizant of that. So as well as the public health work that is advising Lady Dorian and the group that she is chairing, we're also looking, for example, to see how we can feed in some behavioural science in and around psychological input into what's being done. But I think, truthfully speaking, the kind of shorter answer to your question would be, until we actually start progressing jury trials and seeing what issues need addressed, only then are we going to know what more we need to do in order to get more trials up and running as swiftly as we can.
James?
Thank you. Cabinet Secretary, interested in your view on the evidence we heard from Ronnie Ranucci in the previous session. He was putting forward a view that more could be made of the existing court state to get more trials up and running. For example, he gave the example around Glasgow where, muster rooms, jury members could be used to help facilitate court trials. So just interested in your view on that.
Cabinet Secretary.
Well, I have a great amount of respect for Ronnie Ranucci, both as a professional that he is, but also the work that he does in the Scottish Criminal Bars Association. I know certainly from the input that he's given government, it's been very constructive, and he's worked in that very constructive manner. So I think, Ronnie is obviously a member of Lady Dorian's group, and I don't doubt for a minute that he'll be feeding some of that in, and I'm sure the Scottish Courts and Tribunal Service will be giving that due consideration coming from Ronnie. What I would say is, in my discussions with Lord President, I spoke to him last week, and Lady Dorian was also in the call. When we spoke about this issue, they are really leaving no stone unturned in order for the resumption of court business, solemn court business, but also indeed other court business as well. So certainly, where it's possible to look at every single aspect of the physical court estate, I'm certain that will be explored. Where we need to look at other venues outside of the court estate, I'm also sure that will also be explored as part of a potential solution as well. But in short, whatever constructive ideas that Ronnie Ranucci and others have, I'm very confident Lady Dorian and the colleagues at the Scottish Courts and Tribunal Service will give it due consideration.
John Finney, our next question, please. John.
Thank you, Convener. Good morning, panel. And my question's for the Cabinet Secretary, and it's about the backlog of summary trials, Cabinet Secretary. Now, if I noted you correctly there, you referred to them as being stark and eye-watering, the figures. Now, the Chief Executive of the Scottish Court and Tribunal Service, McQueen, advised us that the backlog is likely to exceed 1,800 by August of this year and could exceed 3,000 by March of next year. Went on to explain that with social distancing in place, the court's capacity to hold trials is cut to a third. Do you agree with these estimates? And if so, what do you consider the implications are for both victims and accused, please?
Cabinet Secretary.
Well, it's a really good question from Mr. Finney. I thank him for asking it. There has been some back and forth a fair bit of discussion around the numbers that have been quoted by the Scottish Courts and Tribunal Service, and I know there has been even some disagreement about whether or not that is a true estimate or not. So what I'm quite clear as Cabinet Secretary of Justice is I want to know with absolute clarity, as much clarity as I possibly can, with as much evidence as I possibly can, the true extent of that backlog. So I'm pleased that the Scottish Courts and Tribunal Service, they're working with the Scottish Government's Justice Analytical Services, which you'll know about. They've been in front of committee on many occasions. And what they've agreed to do is work on the modelling of the backlog in some detail. So and what I'll endeavour to do, and I see no reason why not to do this, is that when that modelling is finalised, I'll ensure that it's made public and available to committee and indeed stakeholders in due course. So that work is underway just now. In terms of the impact, I chair the Victims Task Force. I speak regularly to victims' organisations. I'm due to host a virtual Victims Task Force as it was on the 10th of June. And I've read some of the papers related to that. And one of the papers we're going to be examining and exploring, which again, I'm sure we can make public, will be exactly on this issue around the victims' impact thus far. And again, it makes for pretty stark reading. On victims, there's already a level of anxiety. I think you would have heard this from Kate in quite a lot of detail. Already anxiety around a court appearance, and now exacerbated by the fact that there could be a fairly significant, and let's not beat around the bush, a fairly lengthy delay to their trial. For the accused, equally, I'm now starting to see the numbers on remand in prison begin to increase again. That gives me concern. The amount of time that they're being held for in remand gives me cause for concern. I have to say, particularly at a summary level, where people may be being held, possibly even for longer than they would have a sentence, and that to me does not seem right in the interest of natural justice. So for those that are the accused, also there's an anxiety for them to get their case heard, and I think there's some genuine concern. So, we'll move as swiftly as we can, but hopefully as safely as we can, and look to use technology where we can to ensure that we can make some progress so that those anxieties are mitigated, both for the accused and for complainers, and indeed for witnesses, of course.
John Finney.
Thank you for that reply, Cabinet Secretary. And as to the means of addressing that backlog, on 21st April, you stated that work would now focus on 4 options for dealing with the growing backlog without resorting to judge-only trials. That was very clear. The Chief Executive of the Scottish Courts and Tribunal Service has warned that these options are unlikely to have a material impact on the backlog. Do you agree with that statement?
Cabinet Secretary.
Generally speaking, the work that we're going to do to resume trials will make an impact into that backlog, but clearly we're going to have to do, and we are doing, a separate piece of work that's going alongside the restarting of solemn trial and indeed court business, which is how do we address that backlog. There already existed a backlog pre-COVID, and that has been exacerbated by the fact that we've not been able to have court business resuming to any great degree. So there are other options, first and foremost, that we're looking at. As you know, they will not be in place by July, and I think you maybe referenced them in some of your conversation with the previous panel around smaller juries or adjusting sheriff sentencing powers, and they could also potentially have an impact on addressing the backlog. But really, I think our focus is going to be, and the court service focus is now going to, be looking at the summary level crime, because we know that solemn high court trials, although obviously the more serious cases, only represent a very small proportion of the overall backlog. So a fair bit of work simultaneously going into looking at how we address summary business that is backlog.
Thank you, Cabinet Secretary. The next question is for me, and can I ask, do you agree with the Chief Executive of the SCTS that judge-only trials should remain an option to clear the backlog? And why have you responded as I expect, or as you will respond?
Well, my position, and it's fair to say, I'm sure Aidan Queen would reiterate this. He speaks for the Scottish Courts and Tribunal Service. I speak for the Scottish Government, and our position, I think I've made it as clear as I possibly could in a parliamentary statement. The last parliamentary statement I did, and since then as well, that judge-only trials are not an option that we're exploring. They're not an option that any work is going into. They're not an option that I can feasibly see being brought back for consideration at all. And certainly, even if there was a desire and a will to do so, and I don't think there is, but even if there was a desire and a will to do so, Parliament has made its position, I think, pretty clear on that, and I respect Parliament's voice in that regard. So we're looking at other options for sure. We're looking at, as I've mentioned, a smaller number of jurors. We're looking at potentially adjusting sentencing powers. They will require, I think, primary legislation, but we're certainly not exploring and not looking at the option of judge-only trials.
Thank you very much for that, Cabinet Secretary. I wonder if you could maybe elaborate on what other options you think could be considered, and in particular, what are your views on enhanced plea discounts, where an early guilty plea means no trial is necessary, and also on the one suggestion to bring back recently retired, soon to retired senators and part-time High Court judges to be able to hold more court trials, solemn court trials. Cabinet Secretary.
So on the latter point, they are actively being explored again by the Scottish Courts and Tribunal Service. I'm certain that they will look to speak to retired judges. They will look to see how they can potentially recruit more sheriffs. That's all in consideration. And again, it would be appropriate for the Scottish Courts and Tribunal Service to look at that. In terms of further discounting, we know discounting already happens, of course, but further discounting, increasing that discount potentially, I'm wary of that. I have to say that comes largely from my conversations with two groups, one with victims organisations, so I think I wouldn't have to go into too much detail. You can imagine where the concerns would be from a victim's perspective on further discounting. And I think Justice Committee itself has commented on the discounting scheme previously. I suppose the second group of stakeholders that have raised concern about discounting with me have been human rights practitioners and academics, if I can put them into one group for a second, because they fear that an increased level of discounting could put pressure on the accused to potentially plead guilty to a crime, or undue pressure on the accused to plead guilty just because of the size of the discount, as opposed to go through a trial process where they may well be innocent. So I've got some concerns about that option, I have to say, but we'll continue, obviously, in these unprecedented times to keep the discussion going.
Thank you, Cabinet Secretary. Our next question is from Rona Mackay. Rona.
Thank you, Convener, and good morning, Cabinet Secretary, and good morning, Anna. Cabinet Secretary, in your opening statement, you talked about the anxiety for jurors and the possibility of psychological support, etc., for them, which is very encouraging. But my next question, so this question really relates to the safety of restarting jury trials with regard to social distancing and personal protection. Kate Wallace said she wasn't aware of the measures that Public Health Scotland were introducing, and she would like that to be shared with their organisation and the public. So are you satisfied that those tasked with the planning, the resumption of trials, the various bodies such as SCTS are doing so based on the best current health advice from Public Health Scotland, and do you agree that this should be shared as soon as possible? Cabinet Secretary.
So the practical operation, obviously, of the courts is very much a matter for the Lord President and the Scottish Courts and Tribunal Service. So I suppose I should be a little bit careful in terms of what I say here, because it is really a matter for the Lord President. But as a general point, For me, of course, I would expect any of our stakeholders to be getting public health input. And I know from speaking to the Lady Dorian last week that she is getting Public Health Scotland input into the work that she is doing in relation to the restarting of Solemn Trial Working Group. And I know Kate Wallace doesn't sit in that group, but I'm aware that Sandy Brindley from Rape Crisis does, and I'm certain that Sandy feeds some of that information back to the other victims' organisations. What I would also say, that where limited court business is currently taking place, and it is very much in line with protocols on hygiene, social distancing in courts, and that's been agreed between the Scottish Courts Tribunal Service, between COPFS and Law Society have also had an input into that, and that was agreed on the 30th of March. I definitely know before the 30th of March there was a fair bit of discussion around PPE and social distancing, and perhaps there were some teething issues in the beginning. But I have been satisfied that since then good progress has been made. And there may well be a need as we begin more court business for resources in relation to PPE and so on. And of course, I will continue to have dialogue with colleagues at Scottish Courts Tribunal Service about those issues.
Rona.
Thank you for that answer. Yeah, just very briefly, would you anticipate jurors being given plenty of information before they went in, before their date, to say what measures were in place so that they knew what to expect and could feel a bit more reassured?
Cabinet Secretary.
Yes. I think that's going to be important not just for jurors but everybody involved in the case, and I think that's why in the first instance, I know COPFS and the legal profession, they're proactively working together to identify cases where it's maybe more appropriate to pre-record evidence of vulnerable witnesses. Can we begin with looking at cases, or can the court service look at beginning cases that have just one accused and one complainer, and therefore not needing a lot of witnesses or a lot of people to attend court. So that's the right approach to take in the first instance. I do think, yes, information is going to be really important, and we are liaising with colleagues in England and Wales just to see what they're doing in that regard. As you know, they've resumed or began to resume jury trials in England and Wales. So as a learning we can get from there. I do think though that there is just something around, we're going to have to just wait to see how it all pans out. I think we can do all of the education, informational bits. We can do as much as we can around hygiene and social distancing, but I do think there is going to be a reticence and reluctance for people to get involved in jury trials that we're going to have to just have some tolerance with and work through.
Thank you.
Thank you, Cabinet Secretary. Our next question is from Fulton McGregor. Fulton. Fulton.
Thank you, Convener. I was just checking I was not muted there. Yeah, and good morning, Cabinet Secretary. I was actually going to ask you about the use of PPE, particularly in criminal trials, but I think you've covered that in your answer to my colleague Rona Mackay. So I'll just go into what was going to be my second question. What further steps can the Scottish Government take to assure the public generally that it will be safe for them to attend court, whether as a witness, a member of a jury, as you've talked about, or in any other business at all? What more can we be doing to support the public?
Cabinet Secretary.
I suppose it's probably not too much for me to add from the previous answer. I think there is an element of making sure that we're giving as much detailed information around why our court estate is safe. So making sure that there's as much information around the social distancing measures, the hygiene measures that are in place. I think it's also worth doing some work with, of course, the victims' organisations who already play a key role, like Victims Support Scotland, Rape Crisis Scotland, and working with complainers and witnesses around a trial. And pre-COVID days, of course, there was already an anxiety about going to trial. So I think we should work with victims' organisations to see what further support we can give them. But above and beyond that, I think, as I say, we're just going to have a bit of a tolerance. I think initially in the early stages, a bit of a tolerance and understanding that there is frankly going to be some nervousness for people when they are asked to sit in a jury trial as jurors, or indeed attend as the accused or witnesses or complainants, because everybody does have a heightened sense of anxiety, I think, around hygiene. So we just have to have a tolerance of that.
Fulton, are you satisfied with that questioning?
Happy with that, Convener, thank you.
I just wonder on that point, Cabinet Secretary, if I could ask you about, people called to potentially be jurors. You mentioned in panelling, an option is that this could be done completely remotely. Is that something that you would welcome?
Certainly would. I certainly would. And again, when I mentioned that we're looking closely at what's happening in England and Wales, and keeping in touch with colleagues and counterparts down there, I certainly it'd be interesting to see if they're going to do any remote panelling of jurors. At the moment, I think that my understanding is for any new trials that they are doing, they're using court space that is big enough to physically impanel jurors. And of course, they're in a slightly different trajectory in terms of easing of lockdown measures in England and Wales. So I certainly, I don't know for certain that digitally impaneling jurors is definitely part of the consideration. It's something I would absolutely welcome. But at the same time, as I've caveated everything else here, there may be reasons why once we get it up and running, we just deem it to not be appropriate.
Okay, thank you. Shona, next question from you, please.
Morning. All of this is predicated on a balance of risk, whether it's in the justice system or the health system or anywhere else, and trying to balance the risks and whether you're moving too slowly or too fast. Just to ask you, Cabinet Secretary, what makes you believe that the approach being taken in relation to resuming jury trials strikes the right balance and is at the right pace?
Cabinet Secretary.
I suppose, in direct answer to the question, what gives me confidence in that regard is that we are, and the Scottish Courts and Tribunal Service is getting public health input into what they're doing. The First Minister has often said, when it comes to the resumption, of NHS procedures and NHS activity that is non-COVID related, I always remember her using the phrase that we should do it swiftly but safely. And I think that's the same mantra that we've taken in relation to all of our public services and their core business. It should be done swiftly, of course, understanding the damage and the impact delay can do. But ultimately, the primary consideration has to be on public health and safety. And also, I suppose any progress we make has to be in line with the route map as we have it. So, for example, if jury trials were running in large numbers before schools were open, well, this could obviously have an impact, I think, particularly on female jurors being able to attend court. Equally, if we have very limited public transport and we don't have other transport solutions, and that's been looked at by the court service, but we don't have other transport solutions, then clearly that's going to have an impact on particular individuals that don't have a car being able to come into court. So yeah, I think we're striking the right balance. I think you always reflect on these things a bit quicker pace or not, but I think having reflected on it quite carefully, I don't think there's anything more we could have done to move at a significantly quicker pace. And I'm very confident that health considerations are really primary focus for getting this work up and running.
Shona?
Just a thought in terms of jurors who are called, presumably they're obviously going to be from a wide spectrum of society, which could include obviously people who are perhaps more vulnerable. Will all that be worked through in terms of underlying health conditions, issues like that, in terms of whether they would be required to come for jury service?
Cabinet Secretary.
Yeah, so there's already quite a wide-ranging power for sheriffs and the court to excuse somebody from jury service. And I've asked the question myself, does that power need to be widened to take into consideration COVID-19 impacts? And the answer thus far coming back is no. There is a broad enough power that exists for the courts to be able to look at health reasons for excusal. But we'll keep that under consideration. But at the moment, the powers that are there for the courts we take into consideration people's vulnerabilities.
Thank you, Cabinet Secretary. Alistair Allen to ask our next question.
Thank you very much, Cabinet Secretary. I was just wanting to ask briefly about the route map, and without asking you to predict too far into the future, would it be right to say that social distancing is going to be a feature of life in Scotland's courts, probably until phase 4 of the changes to the restrictions that we're all living under?
Cabinet Secretary.
The short answer is yes. I think physical distancing is going to be the norm for all of us for quite a while. You're right. Based on the scientific advice, at least up until phase 4. I suppose, again, some of the obvious points to make, which I know everybody's aware of, but are worth reiterating, that although we'd like to move through the phases in a sequential manner, we do know that in the absence of a vaccine, that we may have to go back before we go forward. That's a real danger. The First Minister was pretty robust on this, I thought, yesterday on our daily briefing, where we saw some disappointing behaviour over the weekend, that actually we may have to tighten restrictions before we ease them. So there shouldn't be an assumption that we'll just progress from phase 1 to phase 2 to phase 3 and to phase 4. We may have to go back. So I think it's quite prudent for the court service to assume and plan there will be social distancing measures in place for quite a period to come.
Alistair?
Thank you. And on the back of that, can I ask, in that case, you've indicated that we can't foresee too far into the future, but given what's been said by other witnesses about the backlog that exists, do you foresee any changes at phase 2 or phase 3 that would have any impact on the backlog? Or, again, without taking away from the public health message which you've given there, do you foresee very little changing in terms of how the courts operate during phase 2 and phase 3?
Cabinet Secretary.
No, I think definitely, we are considering, and I know the Scottish Courts and Tribunal Service are considering each phase and looking at the restrictions and how that might enable more court business to resume. So we certainly expect, and I think it is detailed in the route map to some extent, what more we may be able to do as phases progress. But I suppose the question that I think it was the convener asked me at the beginning, which is, all that work may well take place, but there will still be a considerable backlog. So it's important that we really go kind of eyes wide open into this, understanding that whatever that backlog is, and I mentioned we're doing some work to examine and explore that. And forgive me, I think it was Dunfinny that asked me the question. We will certainly make that public, but clearly we've got to continue to do work on that backlog, and there's not an easy answer to that. There's not one magic solution or panacea that will resolve that issue. But yes, we can make progress and more progress through the phases, but equally we've got to continue simultaneously to do the work on the backlog.
Okay. Next question from Liam MacArthur. Liam.
Thanks, Convener. Good morning, Cabinet Secretary. You touched on some of this in response to the Convener earlier, specifically in relation to discounting, but I'm interested to know what work the Scottish Government has been doing since the round table in mid-April on policy options going forward. Obviously, Lady Dorian's group is looking at practical considerations for reopening courts. The SCTS has been doing its work as well. But what's the Scottish Government been doing on policy options since that roundtable.
Cabinet Secretary.
Yeah, I may have given kind of some indication of this previously, but so the work that Lady Dorian's group is doing, as you know, is looking at the operational aspects of resuming jury trials. What we've been doing as a government is obviously looking to support that work where we can, and Anna Donald, who's on this call, also sits on Lady Dorian's group. But what we've also been doing within government is a range of things. So we're looking at the other policy options. Lee MacArthur will probably remember from the roundtable that he participated in, that there was a kind of coalescing around a few other issues at least to explore. Smaller number of jurors, and also work on potentially changing and altering the sentencing powers of the summary courts. And at the moment that's limited to 1 year in custody, but potentially increasing that to 2 years, or maybe even more. That's a consideration that we're certainly giving. Now we're doing that policy work internally, and so far we've done a bit of work on that. But essentially, we've got to the position that if that was an option, or were options that we wanted to progress, again to help us with the backlog, to help us deal with more court business, then we would, at this stage, our determination is we need primary legislation to do that. So that may require some more potentially emergency legislation. But we're going to continue to see what impact the work that Lady Dorian is doing, and then bring that conversation back to the legal profession, the victims' organisations, and so on and so forth. And furthermore, we've been doing some work, as you probably know, I've already referenced, in relation to the backlog, so modelling some of the figures that are coming from the Scottish Courts and Tribunal Service. So a fair bit of policy work is going on, largely centred on the other options that we agreed to in our roundtables.
And Liam MacArthur, follow up?
Yes, thanks very much, Cabinet Secretary. It leads on, I think, quite nicely to where I wanted to go. Obviously, Ronnie Ranucci was saying earlier about the need for legislation should certain options be taken forward. You've just confirmed that in relation to reducing the size of juries or extending the powers available, sentencing powers available to sheriffs. You've suggested this would require primary legislation, which intuitively seems to make sense. But I wonder whether you could maybe set out the likely timetable for that. Are we likely to see that prior to summer recess, during summer recess? I suppose the concerns about delays in getting up and running and the backlog that others have touched on is that if we do this sequentially, then more time will be lost and greater delays, and therefore the greater the potential backlog. So it'd be helpful if you maybe set out the kind of timeframes that you're working to at the moment.
Cabinet Secretary.
Well, in truth, I couldn't really give Liam MacArthur any substantial detail on that, because I suppose one or two of the options may be quite incompatible with what's being explored and examined at the moment. So, take for example the option of us, the work that Lady Dorian is being explored internally by the Scottish Government, that is not the basis of the work for the work that Lady Dorian is doing. They are looking at continuing to retain the 15-person jury as we currently have in Scotland. Now, if it came to them and the feedback was that we should give this active consideration in terms of bringing forward legislation, I think at that point, once we've monitored how the restarting of jury trials is going, then we would, for example, bring forward primary legislation in that regard. But that would have to come with agreement, as I say, with stakeholders right across the board where we could. I think in terms of sentencing powers for sheriff courts, that is something that we are considering quite actively. I know there are some concerns around that, and I caught the tail end of Ronnie Ranucci's evidence. He was asked about this, and I think that typifies where some of the concerns lie from a government perspective. To give an assurance, we'd only ever look at the lower end of solemn trials to see if we could potentially bring them into summary court business. But again, I couldn't give you clarity on when or if we would do that. It really, I think, depends on, first of all, how many trials can we restart, both at a summary and solemn level, with the current work that is taking place. And if we do think we have to press the button on any of these options, I suppose the reassurance I'd give you is that policy work is being done at the moment, and would be quite easy for us, I think. That's easy relative to everything, of course, but quite easy for us to be able to push the button on that and get the parliamentary process started.
Just further to that, Cabinet Secretary, could you put on record that, of course, while the policy work's being done, that nothing that requires legislation would be rushed, unduly rushed, and that due consideration would be given to this? And also on the same theme, can you confirm that I think there's been a feeling that judge-only trials would speed things up, but would that not also require legislation? Cabinet Secretary.
Yes, to both questions. We won't look to rush it, but clearly if we need to go through an emergency timetable, we discuss that with the Parliament. Of course, the committee would be key to do those considerations. If the committee was content, if the Parliament was content, and the government was content, then of course we could bring measures forward on an emergency basis if we thought that was the appropriate thing to do. But of course, that would only ever be done, as I say, in conjunction and consideration of Parliament's views. And in answer to your second question, yes, of course, we're planning to bring forward provisions in legislation on judge-only trials. We heard what stakeholders had to say, indeed what parliamentarians had to say on that, and as you know, withdrew that. So there's certainly no intention to bring forward that provision back again.
Thank you, Cabinet Secretary. Liam Kerr.
Thank you, Convener. Cabinet Secretary. I'll get straight in. What are your views on the progress that's been made in England and Wales in starting jury trials? And when you said earlier in response to Rona Mackay that there are learnings for us, can you suggest what those might be?
Cabinet Secretary.
I've had good and constructive dialogue with counterparts in England and Wales, and in particular with Robert Buckland, who's of course Lord Chancellor, I put on record as well that our officials have worked well together. There's been a good sharing of information between the court service in England and Wales and our government officials, as well as the Scottish Courts and Tribunal Service. I think, if my memory serves me correctly, but of course I'll correct the record if I'm wrong here, Lady Dorian does sit as an observer on the group and the working group that is looking at resuming jury trials in England and Wales. So that shows the kind of cross-jurisdiction sharing of information, so on and so forth. What I would say in terms of our own progress, first and foremost, we're in a different trajectory and journey when it comes to our own route map and lockdown restrictions, and we have to bear that in mind. Anything we do in Scotland has to be in line with that route map. What I'd also say, and again, forgive me, I'm stating the obvious that you all know, but always worth reiterating for the record, that Scotland is a separate legal jurisdiction, and therefore we should only ever move at the pace that is appropriate for us. I suppose the third point I'd make is although England and Wales are resuming trials, a number of the trials they're resuming are part heard trials. In fact, I think they make up the bulk. And in Scotland, we don't have any part heard trials. We concluded all of our court business, in advance of the announcement from the Lord President of there being no more jury trials. So starting new jury trials comes obviously with its own challenges, and panelling jurors would be the most obvious of those challenges. And I suppose the very last point I'd make is that Justice Analytical Services produced a short paper that outlines what the most up-to-date position is on jury trials in a number of other common law jurisdictions. They looked at England and Wales, looked at Ireland, the Republic of Ireland. They also looked at Northern Ireland, looked at Australia, Canada, Ontario specifically, and also New Zealand. It's interesting, only England and Wales, they're the only jurisdiction out of all of those ones that have resumed courtroom-based jury trials. Well, at the time of that research paper, most certainly. So, I think we're not out of step in that regard, but certainly where we can learn from any other jurisdiction, we should continue to do that.
Liam Kerr.
Yes, thank you for that. You were asked earlier on by, I think, Rona Mackay and Fulton McGregor about safety measures in courts and how we can go about reassuring users. I believe Public Health England and Wales was asked to certify and formally sign off a checklist and safety guidance on measures to reopen courts. Is this something that you'll be exploring doing?
Cabinet Secretary.
Well, again, it would be for the Lord President and Lady Doreen to make a decision on that. I am confident, in fact, I know that Public Health Scotland input is being asked for and is being contributed into the working group that exists at the moment. Whether that would need a formal sign-off or not, I would leave with the Scottish Courts Tribunal Service, but I think that input is going to be absolutely vital to any decisions that are made. But look, as I've mentioned, my understanding is Lady Doreen was an observer in the English and Welsh restarting jury trials working group. So if there is learning to be had there, I'm sure she would be best placed to be able to explore that.
Thank you, Cabinet Secretary. Turning now to summary cases, what discussions has the Scottish Government been involved in on progressing more summary criminal business? And are you confident that summary trials are receiving sufficient priority?
So it has been a topic of discussion, as you can imagine, between myself and the Lord President in our conversations, and it's worth saying that we all understand, and certainly the committee also understands it as well, is that summary business will make up the vast majority of the court's business, and therefore there absolutely has to be a focus on that. In relation to the steps that have been taken in summary business, you may have seen the announcement from the Scottish Courts Tribunal Service as we moved into phase 1 that it was the intention of SCTS to begin opening courts that were closed. So that gives me certainly a fair degree of reassurance. I should say it's not the case that no summary business has been taking place. There has been limited essential summary business, and that's been taking place in the 10 hub courts. But as I say, the plan now is to begin to open further courts. In fact, 5 hub courts that are due to be open tomorrow. What Scottish Courts and Tribunal Service have said, they'll gradually introduce or reintroduce staff first and foremost, and then, of course, once that safety and wellbeing of court staff is established, they will then begin to work their way through that backlog that exists as well. So, I do think summary cases are something are a matter that don't get as much public attention, certainly from a government and then from a SCTS position, are getting a fair degree of focus.
Thank you very much, Cabinet Secretary. That completes our set questions, and I don't have an indication anyone wants to ask a supplementary. So that concludes this evidence session. Can I thank you very much, Cabinet Secretary, and your official for attending the evidence session today. That concludes the public part of today's meeting. The next meeting of the committee will be scheduled at an appropriate date. This will be notified in the business bulletin via the committee's social media. In the meantime, any follow-up scrutiny issues will be dealt with by correspondence, which will be published on our website. As previously agreed, we will now move the meeting into private session, and I suspend the meeting for 10 minutes to allow for a comfort break.